So one of the things I think is really important to do is dispel these misconceptions about privacy law in the United States. And I think there is a misunderstanding about U.S. privacy law, that somehow U.S. privacy law is not as strong as it is in Europe, that somehow Americans care less about privacy, value privacy less than Europeans do. And I think it's important to have these conversations, because I think that the negotiations that we're going to have with Europeans should be based on a clear understanding and not these misconceptions about U.S. law, and also to make clear that the U.S. is not trying to strong-arm Europeans into anything, that we want to work together, mutual respect, to come up with agreements that are agreeable to both of us. And that, as the President said in his inaugural speech, that we reject the false choice between individual liberties and security. We believe that you can have both, and like the Europeans, we want to make sure that we do have both, preservation of our individual liberties and our national security. So, I think it's important to make clear that the U.S. approach to privacy, particularly when it comes to protecting privacy, personal privacy from government intrusion, is very robust. We've got a long history of it. It's in our genetic code. Our country was founded on distrust of government, and our founding fathers made sure to put in our Constitution a Bill of Rights that created zones of privacy from the government. And our Supreme Court, the highest court in the land, the last word on what the Constitution means, has made clear in its case law that privacy is a constitutionally protected and fundamental right, and that the Fourth Amendment of the Constitution, which is what we talk about what we refer to when we talk about data privacy, the overriding function of the Fourth Amendment is to protect personal privacy and dignity from unwarranted intrusion by the state. So it really is a fundamental value for Americans, and we hope to make that clear to the Europeans.